My name is Arpan Banerjee. I'm a research scholar at the Department of East Asian Studies, University of Delhi, and academic counselor here at IGNOU. And I have been teaching you the paper Right to Information, the code of which is BPAE 141. So I welcome you all to today's learning session, and let us begin. So far in this paper, we have studied in the first block, which was relating to an introduction of the concept of RTI. What we have studied in this block is the evolution of this concept of RTI and the achievements of this RTI movement and also the limitations. Moving on, in the second block relating to the RTI Act of 2005, we had studied about an overview of this RTI Act of 2005 in the second unit. Moving on, afterwards we had done the right to information rules in the third unit of the paper. And after that, we had done the Central Information Commission as well as the State Information Commissions. So these were the things that we had covered in the second block of this paper. And in the third block of this paper, we had done in the sixth unit. The third block was relating to the implementation of the RTI Act of 2005 and the issues and challenges that were encountered in its implementation. So in that third block, we had done in the sixth unit, we had discussed the administrative efficiency, transparency and accountability through the RTI Act of 2005 and the issues and challenges that were encountered in ensuring administrative efficiency, transparency and accountability through the RTI Act of 2005. Afterwards, we had discussed the role of the Central Information Commission as well as the State Information Commissions as well as the public authorities. What are the expectations from them and what are the constraints on their working. And moving on, we had done in the 8th unit the RTI Act of 2005 and the constraints that this act faced in its implementation at the district level, that we had done. And finally, in this third block, we had done in the 9th unit the role of the media we had discussed in the implementation of the RTI Act of 2005. And finally, we had also discussed the role of the civil society organizations as well in the implementation of the RTI Act of 2005. And moving on, in the fourth block of this paper, which we had just begun yesterday in the last class, this fourth block is pertaining towards good governance through RTI, the initiatives that have been taken and the impact of those initiatives. As part of that, in the 11th unit, we have done the significance of the RTI for governance. And in today's class, we are going to discuss Unit 12, that is judgments of the Supreme Court and the High Courts, which have proved to be instruments for facilitating the enforcement of RTI. That we'll be discussing. And also in the 13th unit, we will be discussing the good practices and their successes, the efforts to realize transparency and accountability. So these are the two units that we shall be discussing in today's class. So let us begin today's class by discussing the 12th unit, that is judgments of the Supreme Court and the High Courts, that is the judiciary, which have proven to be instruments for facilitating the enforcement of the Right to Information Act. So, as we all already know, as we have already discussed, that the Constitution of India, it does not expressly provide for any right to freedom of information as such. However, the third part of the Constitution dealing with fundamental rights and the fourth part of the Constitution, which deals with directive principles of state policies, they are totally silent on this subject of freedom of information. However, what we observe in Article 19, Clause 1, Subclause A of the Constitution is that it confers the right to freedom of speech and expression. And RTI, it is an inherent part of this right to freedom of speech and expression. So the right to freedom of speech and expression, it includes RTI as well, and it comprehends the right to know or the right to receive information regarding matters of public concern. So this right, it also emanates from the preamble of our constitution, which secures to all its citizens liberty of thought and expression. So these constitutional provisions securing the right to information to citizens, they have received an expansive treatment by the Supreme Court of India, and the Indian Apex Court, that is the Supreme Court, through its progressive interpretation, has read this valuable right as a part of Article 19, Clause 1, Subclause A. So the Supreme Court of India, it has observed that the right to know is implicit in the right to free speech and expression. And also disclosure of information regarding functioning of the government, it must be the rule. So the Supreme Court of India in SP Gupta versus Union of India in 1981, in that case, in the SP Gupta versus Union of India case in 1981, the Supreme Court of India, it had decided by a 7-judge bench. It added a fresh liberal dimension to the need for disclosure in matters relating to public affairs. So, in the instant case, it was held that in regard to the functioning of the government, disclosure of information, it must be an ordinary rule, and secrecy, it must be an exception, not a rule. So, secrecy is justifiable only when it is demanded by the requirement of public interest. But in ordinary situation, disclosure of information, it must be the ordinary rule and not secrecy. Secrecy, it must be an exception which should be justifiable only when it is demanded by the requirement of public interest and not otherwise. So the Supreme Court of India in SP Gupta versus Union of India 1981, it decided that in regard to the functioning of the government, disclosure of information is the rule. It's an ordinary rule, and secrecy is an exception, which is justifiable only when it is demanded by requirement of public interest. And in this case, in SP Gupta versus Union of India, which is the first case we are discussing today, the Supreme Court of India decided by a 7-judge bench. It added a fresh liberal dimension to the need for disclosure in matters relating to public affairs. So that is something that is very important. Moving on, it was further held by the Supreme Court of India that the disclosure of documents relating to the affairs of the state, it involves two competing dimensions of public interest. Now, what were those two competing dimensions? They were the right of the citizen to obtain disclosure of information, which competes with the right of the state of protecting the information relating to its crucial affairs. In addition, it was also held that in deciding whether or not to disclose the contents of a particular document, a judge must balance the competing interest, and the judge must make his or her final decision depending upon the particular facts which are involved in each individual case. So the court had decided that in deciding whether or not to disclose the contents of a particular case, the judge must balance the competing interest and must make his or final decision depending upon the particular facts which are involved in each individual case. So this is what the court held, that the right of the citizen to obtain disclosure of information, it competes with the right of the state of protecting the information relating to its crucial affairs. This is a very important thing that the Supreme Court held. And it is very important in this matter, in this context, to note that it was considered that there are certain classes of documents which are necessarily required to be protected. Now, what are those classes of documents which are necessarily required to be protected? They are the cabinet minutes, documents concerning the national safety, documents which affect diplomatic relations or which are related to the state secrets of the highest importance, and other such documents in respect of which the court would ordinarily uphold the government's claim of privilege. So, implicit in this assertion is the proposition that in transactions which have serious repercussions on public security, secrecy can be legitimately claimed because it would then be in the public interest that such matters are not publicly disclosed or disseminated. So the court it further added that to ensure the continued participation of the people in the democratic process, they must be kept informed of the vital decisions taken by the government and the basis on which those decisions have been taken. So democracy, therefore, it expects openness, and openness is a concomitant of a free society. So, for like sunlight is the best disinfectant, similarly, openness is a concomitant of a free society, and democracy it expects openness. And it is equally important to be alive to the dangers that lie ahead. So the Supreme Court it held that to ensure the continued participation of the people in the democratic process, they must be kept informed of the vital decisions that are taken by the government and the basis on which those decisions are taken. So if we see, it is extremely important to realize that undue popular pressure brought to bear on decision makers in government, they can have frightening side effects. So popular pressure it at times can have frightening side effects also. So if every action taken by the political or executive functionary is transformed into a public controversy, and if it is made subject to an inquiry to soothe popular sentiments, then it will undoubtedly have a chilling effect on the independence of the decision maker, who may find it safer not to take any decision at all. So this kind of a thing, if it happens, then it will paralyze the entire system, and it can also bring the system to a grinding halt. So we have two conflicting situations which are almost enigmatic, and we think the answer is to maintain a fine balance which would serve public interest. So in the People's Union for Civil Liberties versus Union of India case 2004, the Supreme Court of India, in this is the second case that we are discussing today, the People's Union for Civil Liberties versus Union of India 2004. And in this case, the Supreme Court of India, it held that the RTI is a facet of the freedom of speech and expression, which is contained in Article 19, Clause 1, Subclause A, and of the Constitution of India. And the Supreme Court, it also held in this People's Union for Civil Liberties versus Union of India case of 2004. In this case, the Supreme Court of India also held that such a right, that is the right to information, which is a facet of the freedom of speech and expression, this right to information, it is subject to any reasonable restriction in the interest of the security of the state, and it is also subject to exemptions and exceptions also. So the Supreme Court of India also said in this case that there is no question of the fiduciary withholding of information relating to the beneficiary from the beneficiary himself. So the fiduciary cannot withhold information relating to the beneficiary from the beneficiary himself. Fiduciary here is the body which is authorized to give the information to the beneficiary. So when an examinee is permitted to examine an answer book or obtain a certified copy, the examining body is not really giving him some information which is held by it in trust or confidence, but is only giving him an opportunity to read what he had written at the time of examination or to have a copy of his answers. So that is very important to remember, that when an examinee is permitted to examine an answer book or obtain a certified copy, the examining body is not really giving him some information. Cannot be considered as an information which is held by it in trust or confidence, but it is only giving him an opportunity to read what he had written at the time of examination or to have a copy of his answers. So therefore, in furnishing the copy of an answer book, there is no question of breach of confidentiality, privacy, secrecy, or trust. And the Reserve Bank of India, it can't deny information under right to information, claiming fiduciary relationship Reserve Bank of India versus Jayanti Lal Mistry 2016. So the Reserve Bank of India also cannot deny any information, right, claiming that it may harm the financial interest of the country. No. This was held by the Supreme Court in the fiduciary relationship Reserve Bank of India versus Jayanti Lal Mistry in 2016. So the main issue that arose for consideration in this case was whether all the information sought for under the RTI Act of 2005, it can be denied by the Reserve Bank of India and other banks to the public at large on the ground of economic interest, commercial confidence, and fiduciary relationship with other bank on the one hand and public interest on the other. So that was the issue which was decided in this fiduciary relationship RBI versus Jayanti Lal Mistry of 2016. That main issue that arose for consideration in this case was whether all information sought under RTI Act 2005, it can be denied by the RBI and other banks to the public at large on the ground of economic interest, commercial confidence, and fiduciary relationship with other banks on the one hand and public interest on the other. So the Supreme Court, it held that the Reserve Bank of India, it does not place itself in a fiduciary relationship with the financial institutions, because the reports of the inspections, statements of the bank, and information related to the business obtained by the RBI, they are not under the pretext of confidence or trust. So the RBI is supposed to uphold public interest and not the interest of individual banks. Hence, the RBI is clearly not in any fiduciary relationship with any bank. So, the main characteristic of a fiduciary relationship was also described by the Supreme Court of India, and the Supreme Court of India held that the main characteristic of a fiduciary relationship is trust and confidence, something that the Reserve Bank of India and the banks, they lack between them. So the Reserve Bank of India has no legal duty to maximize the benefit of any public sector or private sector bank, and there is thus no relationship of trust between them. However, the Reserve Bank of India has a statutory duty to uphold the interest of the public at large and the depositors also. The country's economy and the banking sector is, of course, managed by the Reserve Bank of India. That is their statutory duty. But they do not have any legal duty to maximize the benefit of any public sector or private sector bank. So there is no relationship of trust. There is no fiduciary relationship between the RBI and the banks. And hence the Reserve Bank of India, it ought to act with transparency, and it is duty bound to comply with the provisions of the Right to Information Act and therefore disclose the information that is sought by the respondents herein. That includes information including commercial confidence, trade secrets or intellectual property, the disclosure of which would harm the competitive position of a third party. This was held by, in the case, the Institute of Chartered Accountants of India versus Shaunak H. Satya and others in 2011. So in this case, the Supreme Court of India held that the appellant is entitled to claim a copyright in regard to the question papers, solutions and model answers, instructions relating to evaluation as the said materials constitute intellectual property of the appellant. However, the exemption under Section 8, Clause 1, Subclause D, it will not be available if the information is merely an intellectual property. That is what the Supreme Court held in the Institute of Chartered Accountants of India versus Shaunak H. Satya and others in 2011. The exemption under this section is available only in regard to such intellectual property, the disclosure of which would harm the competitive position of any third party. And the appellant has not been able to demonstrate that the disclosure of the said intellectual property, including instructions and solutions or model answers, would harm the competitive position of any third party. So information can be sought under the RTI Act at different stages or different points of time. Now, what is exempted from disclosure at one point of time may cease to be exempted at a later point of time, depending upon the nature of exemption. So similarly, if information relating to the intellectual property, that is the question papers or the solutions and model answers and instructions in regard to any particular examination conducted by the appellant, cannot be disclosed before the examination is held, as it would harm the competitive position of innumerable third parties who are taking the said examination. But the position will be different once the examination is held, that is after the examination. So disclosure of question papers or model answers and instructions in regard to any particular examination would not harm the competitive position of any third party once the examination has already been held. So an appellant for application for information would be rejected under Section 9 of the RTI Act only if information sought involves an infringement of copyright subsisting in a person other than the state. So the Institute of Chartered Accountants of India, being a statutory body, it was created by the Chartered Accountants Act of 1948, is considered as a part of the state, and the information sought is a material in which the Institute of Chartered Accountants of India, it claims a copyright. So providing access to information in respect of which the ICAI holds a copyright, it does not involve infringement of a copyright subsisting in a person other than the state. So therefore, the ICAI is not entitled to claim protection against disclosure under Section 9 of the RTI Act. This was held by the Supreme Court of India in this case which we are discussing, that is the Institute of Chartered Accountants of India versus Shaunak H. Satya and others. This is a case of 2011 that we have been discussing in today's class. So a body, institution or an organization which is neither state within the meaning of Article 12 of the Constitution or is neither a part of the instrumentalities of the state, it may still answer the definition of public authority under Section 2, Subclause H, Section 2, Clause H, Subclause D, 1 or 2. So the court held that the expression that is controlled, which figures in between the words body owned and substantially financed, it means control by the appropriate government. It must be a control of a substantial nature and not mere supervision or regulation. So the RTI Act, it does not have the effect of either abrogating or repealing all other enactments. That is, overriding effect of RTI Act is only to the extent of inconsistency. This was held by the Supreme Court in PC Wadhwa versus Central Information Commission. That the RTI Act, it does not have the effect of either abrogating or repealing all other enactments. So the overriding effect of RTI Act is only to the extent of inconsistency and not otherwise. So the petitioner in this case, that is PC Wadhwa versus Central Information Commission, in this case the petitioner had moved an application under the RTI Act 2005 to the Registrar General census operations, seeking information regarding certain leaders of the nation in public interest. The same was rejected, holding that for preparing census, facts are collected from individuals in a household, which are confidential in nature and used only for statistical purposes. So, the question which arose here before the Supreme Court of India was whether the explicit provisions of the Census Act of 1948 they stand abrogated by the overriding effect given to the RTI Act of 2005, and the Supreme Court held that the RTI Act it does not have the effect of either abrogating or repealing all other enactments dealing with furnishing of information to an information seeker, and the overriding effect of the RTI Act is only to the extent of inconsistency. This was held by the Supreme Court of India in the PC Wadhwa versus Central Information Commission case, which involved the Census Act of 1948. So, the provision of the Section 15 of the Census Act of 1948 they are not inconsistent with the provision of Section 8, Clause 1, Subclause J of the RTI Act of 2005, and they can both be read harmoniously. So, accordingly, Section 22 of the RTI Act of 2005 will not come into operation and it cannot sustain the pleas of the appellant. This is what the Supreme Court held in this PC Wadhwa versus Central Information Commission case. Furthermore, it is apparent that the appellant wants to elicit information about the religion of such public persons. So, India being a socialist, secular, and democratic republic, the Supreme Court held the quest to obtain information about religion, professed or not professed by a citizen, cannot be in any event be considered to be in public interest, and hence such information is strictly confidential as per Section 15 of the Census Act of 1948. So you cannot ask for information regarding the religion of a person. That cannot be sought. So mere terming of the members of the family in respect of which the information is sought as public figures and leaders of the nation cannot change the statutory impact of the above provision, and it is thus evident that the petitioner is making efforts to make unjustified inroads. The court held in this PC Wadhwa versus Central Information Commission case that the petitioner is making efforts to make unjustified inroads into the privacy of the said individuals, even if they are public figures. So, the Supreme Court of India it said that the RTI Act of 2005 it does not have an overriding effect. So, it does not have an overriding effect. This is what the Supreme Court of India held. And the secrecy, the privacy of individuals that cannot be in any case sacrificed, even if those individuals are public figures or quote unquote leaders of the nation. So, India being a secular, socialist, democratic republic, the religious information it cannot be disclosed under Section 15 of the Census Act of 1948. So, consequently, the information which is supplied to the census officer it cannot be made public in view of the statutory bar that is imposed by Section 15 of the Census Act, which is not inconsistent with Section 22, read with Section 8, Clause 1, Subclause J of the RTI Act of 2005. So, the court also held here, the Supreme Court, that in this case of Khanapuram Gandhaiya versus Administrative Officer and others 2010, that the litigant cannot seek information as to why and for what reasons the judge had come to a particular decision or conclusion. So this was held by the Supreme Court of India in Khanapuram Gandhaiya versus Administrative Officer and others 2010, that the litigant cannot seek information as to why and for what reasons the judge had come to a particular conclusion or decision. So in the present case, the Supreme Court held that, of course, under the RTI Act, an applicant is entitled to get copy of the opinions, advices, circulars, and orders. But the applicant cannot ask for any information as to why such opinions or advices or circulars or orders have been passed, especially in matters that are pertaining to judicial decisions. So a judge speaks through his judgments or orders passed by him or her. So if any party feels aggrieved by the order or judgment passed by a judge, the remedy available to such a party is either to challenge the same by way of appeal or by revision or any other legally permissible mode. No litigant can be allowed to seek information as to why and for what reasons the judge had come to a particular decision or conclusion. This is what the Supreme Court held in Khanapuram Gandaiya versus Administrative Officers and Others case in 2010. So, no litigant can be allowed to seek information as to why and for what reasons a particular judge had come to a particular decision or conclusion in a specific case. And a judge is also not bound to explain later on that for what reasons he or she had come to such a conclusion. So this is not under the RTI. So under Section 6 of the RTI Act, an applicant is entitled to get only such information which can be accessed by the public authority under any other law for the time being in force. The answers sought by the petitioner in the application could not have been with the public authority, nor could he have had access to this information, as a judge cannot be expected to give reasons other than those that have been enumerated in the judgment or order. So also the court held that marks awarded to candidates in civil service examination, they also cannot be disclosed under the RTI. So this was held by the Supreme Court in the UPSC versus Angesh Kumar and others case of 2018, and also in the unsuccessful candidates in the civil service preliminary examination as per this case. In this case, that is the UPSC versus Angesh Kumar and others 2018. In this case, unsuccessful candidates in the civil service preliminary examination of 2010, they had approached the High Court for a direction to the UPSC, Union Public Service Commission, to disclose the details of marks, raw and scaled, awarded to them in civil services preliminary examination of 2010. So the Supreme Court of India in this case observed that, weighing the need for transparency and accountability on the one hand and the requirement of optimum use of fiscal resources and confidentiality of sensitive information on the other, information sought with regard to marks in the civil service examination, they cannot be directed to be furnished mechanically. This is what the Supreme Court of India held in the UPSC versus Angesh Kumar and others case of 2018, that weighing the need for transparency and accountability on one hand and requirement of optimum use of financial resources on the other, and confidentiality of sensitive information on the other, information which is sought with regard to marks in civil service examination cannot be directed to be furnished mechanically. And also, furnishing raw marks will cause problems which would not be in public interest. However, if a case is made out where the court finds that public interest requires furnishing of information, the court is certainly entitled to do so in a given fact or situation. And if rules or practices so require, then certainly such rule or practice can be enforced also. Now let us discuss a case regarding the nature and function of the Information Commissioner, since this unit is regarding the judgments relating to RTI by the Supreme Court and the High Courts. So in this case, the Namit Sharma versus Union of India case, in the Supreme Court, it held that Information Commission is a judicial tribunal having the essential trappings of a court, and disclosure of information, it may involve the question of prejudice to a third party. And as such, the court, it read into the act a judicial mind requirement. So to be appointed to the Information Commissions, an individual must possess judicial acumen and expertise. So, judicial acumen and expertise must be there in an individual if he or she is to be appointed in a information commission. A requisite to fairly and effectively deal with the intricate questions of law that would come up for determination before the information commission. Against the decision, the government it filed a review petition with the Supreme Court contesting several parts of the decision in the Namit Sharma versus Union of India. And the question before the court was whether its previous reading into the RTI Act of judicial experience requirement it constituted an error apparent on the face of the record. So the Supreme Court of India it held that the specific powers and functions possessed by the information commissioners, which are pursuant to section 18, 19 and 20 of the Act, were not so much judicial functions as administrative ones. And specifically in deciding whether a citizen should or should not get a particular information which is held by or under the control of any public authority, the Information Commission does not perform the judicial function of deciding a dispute between two or more parties concerning their legal rights. This is what the Supreme Court held. Other than their right to get information in possession of a public authority. So, in furnishing information, in providing information, or in deciding whether a citizen should or should not get a particular information, which is under the control of a public authority, the information commissions they are not performing any judicial function. They are just deciding a dispute between. They are just giving the information that is in possession of a public authority. They are not deciding a dispute between two or more parties concerning their legal rights. So the information commissions, when they are giving information to a person which is sought by a person, and information which is held by a public authority. So when they are providing information to a person, to a beneficiary, which is held by a public authority, they are not performing a judicial function. They are not deciding a dispute involving legal rights of two or more parties. They are just merely giving information to that person which is in possession of a public authority. So this is what the Supreme Court of India held in Namit Sharma versus Union of India case. And the Supreme Court it also clarified that in carrying out its administrative functions, the Information Commission must act in a fair and just manner, following the procedure laid down in the Act. However, the court also rejected the notion that acting in such a manner it requires judicial experience, training, and acumen. And with respect to the argument about third-party rights, the Supreme Court of India found that the work of the Information Commission it does not involve deciding the rights of a third party, but rather whether the information which is held by or under the control of a public authority in relation to or supplied by that third party. So, this is what we have discussed as part of the judgments of the Supreme Court and High Courts regarding right to information. We discussed many cases in today's class. The final case was the Namit Sharma versus Union of India case. So, moving on, we will discuss the 13th unit of this paper, which is regarding good practices and success, efforts to realize transparency and accountability. So, as we all know, that good governance it constitutes the cornerstone of every democracy. And the need for good governance and necessity for state machinery to work for the welfare of the people, it has been universally accepted. And good governance is characterized by transparency, accountability, and responsiveness. Also, there is a vital linkage that exists between good governance and RTI. So, RTI is being increasingly recognized as an important mechanism we have already discussed to promote openness, transparency, and accountability in government administration. And RTI is a fundamental human right, and it is a launching point for the realization of other civil, political, economic, social, and cultural rights. Also, access to information not only promotes openness, transparency, and accountability in administration, but it also facilitates active participation of people in the democratic governance process. So, access to information, it not only promotes openness, transparency, and accountability in administration, but it also facilitates active participation of the people in democratic governance process. And in this unit, we will be discussing the efforts in the form of some of the good practices that are being successfully adopted by various agencies for implementation of the RTI Act. So, in this unit, we will also bring forth the benefits, the outcome, and lessons that are learned by the concerned public authorities during implementation of these good practices. And in this unit, we will also be highlighting some good practices which are related to the RTI and which have been successfully implemented at various levels with major focus on the following key aspects. So, we will focus on the use of information communication technology to strengthen the implementation of the RTI Act, also the effective use of the RTI Act to improve access of marginalized population to specific government schemes like the Mahatma Gandhi National Rural Employment Guarantee Scheme and the Public Distribution System, the PDS. Also, we will be discussing the implementation of the suo motu provisions of the RTI Act and also other good practices, including awareness generation, that we will be discussing. And we'll also be discussing the use of ICT to strengthen the use of information communication technology to strengthen the right to information. So, as we all know, the Directorate of Personnel and Training, the RTI Online, it has been launched. The DOPT RTI Online, it has been launched to facilitate citizens in filing RTI applications and public authorities in managing and monitoring the Department of Personnel and Training. DOPT Government of India introduced the RTI Online, which can be accessed through the rtionline.gov.in website. Also, Jankari, which is a facilitation center. This is also a very successful RTI center, facilitation center. So Bihar, it has become the first state in the country which launched a helpline in January 2009, where people can file complaints against the government officials who have harassed them for seeking information by using the RTI tool. And the facilitation center is called Jankari. And it is an innovative and effective use of information communication technology for expanding the base of the right to information. And it is a unique experiment, first of its kind in India, which has aimed at information empowerment of the people. So, to overcome the issues of digital divide and illiteracy, the government of Bihar has used voice communication over phone line. And ease of communication is a key to this project's success. So, this Jankari, which is a facilitation center launched by the government of Bihar, it is a successful project. And this system, it has enabled the citizen to file an application for seeking any information under the RTI Act without any hassles of approaching the public information officer of the concerned department or purchasing a postal order for the requisite right to information application. So we can see how this Jankari Facilitation Center has proved to be extremely effective. And the primary and mandatory requirement of submitting the RTI application fee, it could be fulfilled by paying at a premium rate to the service provider BSNL, that is Bharat Sanchar Nigam Limited. So the information communication technology initiative, it has led to the empowerment of the common citizens. And it has also created peer pressure and enabling environment for the government's delivery system. And the citizen with ease, sitting at home now, can get information in the languages he or she understands. And the power of information is now just a phone call away with initiatives like the rtionline.gov.in that we discussed by the Directorate of Personnel and Training, or DOPT, and also with initiatives like the Jankari, which is a facilitation center. So this initiative, it has no doubt helped in introducing transparency in functions of the government, the Jankari initiative, and the different initiatives of promoting information communication and technology. Besides this, it has also indicated areas of improvement as well as sectors demanding state intervention. There is another initiative that is the dial.gov. So it is an interface to access information on welfare schemes and the government with an aim of welfare of the citizens. Every year it launches various projects in several domains at the central and state levels. India's large population base with complex heterogeneity, it makes the implementation and delivery of welfare programs as one of the most difficult tasks for the government. So spreading awareness about these government programs is also a Herculean task that requires huge amount of investment. So the dial.gov, it is a unique single gateway through which different schemes and programs of the government are matched with the targeted beneficiaries who are scattered under different demographics. So this is a very important unique single gateway that we are discussing. It is an interface to access information on welfare schemes, that is the dial.gov, and the government attempt through this dial.gov is to make special efforts to reach the marginalized sections of the society and to bring them into the mainstream by providing targeted benefits through focused schemes and programs, and also to provide a single window access to the information about the services that are being provided by the government to its citizens and other stakeholders. So this portal, dial.gov, this serves all these purposes. So it is a single window access portal from where information about the services being provided by the government, by the central and the state governments for the welfare of the citizens, these informations they can be easily obtained. And the effort of the government is to reach the marginalized sections of the society and to bring them into the mainstream by providing targeted benefits through focused schemes and programs. And also dial.gov service is a common man's interface for information on the government welfare schemes and benefits. So the aim through the dial.gov is to bridge the existing gap between the beneficial information and the beneficiary. So this portal, it is a comprehensive, accurate, reliable and one-stop source of information. So it has been developed as a solution where a user can find useful information regarding any service, scheme or benefit that is being provided by the center or the state government. So now let us discuss the e-governance initiatives for right to information at Hamirpur, Himachal Pradesh. So many states in India, as we know, they are implementing a myriad of e-governance projects that are aimed at improving public service delivery, bringing greater transparency in government processes and ensuring more effective accountability. So certain initiatives had been undertaken in Hamirpur district of Himachal Pradesh for implementing the RTI through e-governance. The ultimate aim here was to improve the information regime and information retrieval system for easier access to the citizens. So the aim was to improve the information regime and the information retrieval system for easier access to the citizens. And RTI centers, they have been set up at all levels till the villages in Himachal Pradesh, Hamirpur. And these self-contained centers, they provide information to the citizens about every government activity done through that level. Also, computerized display boards have also been installed, which display the information relating to procedure, formalities, fees, etc. for every public service and governmental activity. And also e-Suchna kiosks, they have also been set up, e-Suchna kiosks. They have also been set up at the sub-divisional level in Himachal Pradesh to provide useful and important information to the citizen through a user-friendly touch screen. And also up-to-date status of the implementation of various development schemes in every panchayat can be accessed through these kiosks, And the ERTI directory, which contains details of public information officers, assistant public information officers, and appellate authorities, that has also been put on the website. So the websites are being maintained and is also accessible on the e-Suchna kiosks. So the status of the RTI cases, right to information cases or appeals, and the right to information directory, the right to information act or rules, the list of public information officers or assistant public information officers and appellate authorities, and the proactive disclosure documents, they have also been made available online. And display boards giving information about the RTI Act, Right to Information Act, and the public information officers, assistant public information officers, and the appellate authorities, they have also been put up in all the panchayat offices. So these initiatives, they have led to trouble-free access to information to the citizens, and these initiatives have also enhanced transparency and efficiency in administration. And similar kinds of initiative have also been initiated in other states, some of which are highlighted below. So the first such initiative is the information kiosks that have been set up in Uttar Pradesh. So the Lokwani project is one such project which has been launched by the government of Uttar Pradesh. So the Lokwani, it is a public-private partnership e-governance program which has been initiated in Sitapur district of Uttar Pradesh. And the Lokwani, it means voice of the people in Hindi. It is a commitment to the people in providing them with transparent and accountable system of governance. So, as IT literacy is very low in Sitapur, information kiosks have been started which form an interface between government and citizens. And this model has also been replicated in other districts as well. So, the Nagrik Suchna Kendra in Kanpur Dehat district, as part of which a touch screen information kiosk has been set up in Kanpur Dehat district under the Nagrik Suchna Kendra scheme. And also this kiosk, it provides information related to various issues and services. And besides this, the kiosk also provides print services such as print of pay slips of employees as well as pension slips, print of block and district maps, etc. So now let us discuss the E-Jan Sampark project of Chandigarh. So the E-Jan Sampark kiosks, they have also been set up in each sector and each village of Chandigarh to enable residents to access information and avail services with ease. So the project, it especially helps those who are without IT connectivity, and it provides a single efficient information dissemination system to the citizens for availing the government services. So this E-Jan Sampark kiosk of Chandigarh, that has also proved to be a very significant milestone in ensuring the right to information in Chandigarh. And through this E-Jan Sampark scheme, kiosks have been set up in each sector and in each village of Chandigarh to enable the residents of Chandigarh to access information and avail services with ease. And this project, it has especially helped those who are without IT connectivity, and it has also provided a single efficient information dissemination system to the citizens for availing the government services. There is another portal, that is the My Neta web portal, which ensures transparency and accountability in electoral processes. So the Association for Democratic Reforms, a non-partisan NGO, has developed a website called myneta.info in order to exhibit the information pertaining to candidates' affidavits on a centralized platform. So herein, the citizens, they can access information easily, free of cost and round the clock. And on this information, on this website, that is myneta.info, the information about the candidates is housed in a well assorted manner, the election wise and constituency wise as well. So on this myneta.info portal, The purpose of this portal was to ensure transparency and accountability in the electoral processes. An Association for Democratic Reforms, which is a non-partisan NGO, they have developed this website to exhibit the information pertaining to the candidates' affidavits on a centralized platform. And in this on this website, the citizens they can access information easily, free of cost and round the clock. And also on this website, the information about the candidates is housed in a well assorted manner, and also election wise and constituency wise as well. And the details of the candidates, along with the digital copies of the original affidavits, as well as digitized searchable data, they are also available here. And My Neta portal, it has also enabled citizens to make an informed choice while electing their representatives, which is first and foremost strength of democratic process. And also this My Neta portal, which was created by Association of Democratic Reforms to ensure more transparency and accountability in the electoral process. This portal has also enabled proactive disclosure of information relating to candidates, and also the easy availability of background information of the candidates. They have helped in building faith and interest in the electoral process. So in this class, we have first of all we have discussed the different cases by the Supreme Court of India, the different judgments of the Supreme Court of India and the Honorable High Courts. So beginning with the SP Gupta versus Union of India case, in which we decided that how the Supreme Court of India had added a fresh liberal direct dimension to the need for disclosure in matters relating to public affairs, and how the Supreme Court said that disclosure must be the rule and secrecy must be an exception, not the other way around. And afterwards, we had also in this class discussed the case, that is People's Union for Civil Liberties versus Union of India, in which the Supreme Court of India held that the right to information, it is a part of the right to freedom of speech and expression as given in Article 19, Clause 1, Subclause A of the Constitution of India. And the certain reasonable restrictions on this right to freedom of speech and expression, they are also there. So, and also regarding the fiduciary providing information to the beneficiary also, the Supreme Court of India made it clear that the fiduciary cannot deny or cannot withhold information relating to the beneficiary to the beneficiary. And also we discussed another case, that is RBI versus Jayantilal Mistry. Again, it was relating to fiduciary relationship, in which the Supreme Court of India held that the Reserve Bank of India does not have a fiduciary relationship with other banks. And afterwards, we also discussed this case, the Institute of Chartered Accountants of India versus Shaunak H. Satya, which was regarding answer sheets, and how the Supreme Court of India held that answer sheets are basically intellectual property of the applicant. And also question papers or material related to the examination, they cannot be disclosed before the exam, but they can be disclosed after. Case also we have discussed in this paper. In today's class, we have discussed that. And also another very important case that we discussed in today's class was the PC Wadhwa versus Central Information Commission, in which the Supreme Court of India said that religious information cannot be sought and the RTI does not have an overriding effect. This was relating to the Census Act of 1948. So we discussed many important cases, and also the Angesh Kumar versus UPSC case. So these are some of the cases that we have discussed in today's class. And moving on, we discussed some of the initiatives by the different state governments to some of the good practices and some of the efforts to realize transparency and accountability that we have discussed. For example, the Jankari, which is a facilitation center. So thank you so much. Namaste.